Mr. Buller.
May it please the court. This is one of those cases where it is very important to break past all the noise and all of the speculation and to look very carefully at what the record says and what the law says. If we look carefully at the record, what we see is that the defendant has not met his burden of proof by a preponderance of the evidence. As Judge McDonald says at the Court of Appeals, there is a failure of proof in this case. And if we look carefully at the law, we see that the defendant has not made out the distinct, separate elements of a Sixth Amendment violation. I recognize my time up here is limited, so I'm going to focus on the second and the third prongs of that Sixth Amendment test. I want to focus on agency and on deliberate elicitation. For agency, the case law is almost unanimous that we want a bright line rule here, and the rule is, was the informant instructed by the police to gather information from a particular defendant? And the record here is very clear on this point. The police officers never asked Carl Johnson to do anything. They never gave him any instructions. They never told him what to do. Officer Smithy says that. Officer Clarahan says that. And then Carl Johnson, the informant himself, says that. There's no contradictory evidence anywhere in this record. All the police said was that if Mr. Johnson heard anything new about this Broadway condominium's murder, he should let the police know. And this is what the police do every time there's a major crime. This is what the Polk County Crime Stoppers do when they put those billboards up on the interstate. They say, do you know this person? Do you know anything about this crime? If so, call this police hotline. There's a reward. That's the functional equivalent of what we have here. The police approached Mr. Johnson. They said, if you hear anything about this crime, come tell us. We want to know, because it's the police's job to investigate, and they're allowed to enlist the help of the public. What we see in the defendant's brief and what we see in the Court of Appeals majority opinion or plurality opinion, or however we're going to describe it, what we see is a lot of guesswork about what might have or could have happened during this meeting between Officer Smithy and Clarahan and between Mr. Johnson. But appellate courts aren't allowed to guess about what happened. We are strictly limited to what appears in the record, and what we have in the record is clear, it is uncontroverted, everyone agrees. No instructions were ever given to these informants.
So your view, I take it, would be there could never be an implied agency.
I think under some very, very rare circumstances, if the record discloses perhaps that literally there is a wink and the nod and the cops say, well, we can't tell you what you should go do, but it would be great if you asked this guy some questions. In that extreme, somewhat farcical example, I'll give you, we could have implied agency there, but our facts in this case are so far from that. No instructions were ever given.
Let me just press a little further, I'm sorry, because I think it's undisputed, I think. We'll see what Mr. Simmons has to say, but I think your point, I understand it clearly. There's nothing that says, go get some information from him, ask him these 3, 4, 5 questions or whatever. There's nothing like that in the record. And I take it what there is in the record, frankly, is pretty much undisputed. The question is, what inferences do you draw from it? And ordinarily, if this were a commercial law case and the question was implied agency, there are lots of situations where implied agency can be found, kind of short of what you're describing, I think. And so I gather, and I know you'll correct me if I'm wrong, but I gather what you're saying is no. Generally speaking, we got to be express, and maybe in a few really narrow circumstances you might find implied agency, but Justice Apple, don't go off on the implied agency you might find in an insurance contract or some such thing. That's too generous. We have a different approach here. Am I mischaracterizing your position? And please help me.
I think your characterization is fair, and I want to point out that that's really what the Wilson case from the United States Supreme Court says. Instructed is a very active verb. It means you tell someone to do something. It doesn't mean that someone could guess what you really might mean is something else. But I do want to talk a little bit about that commercial agency point you raised, because I don't think we even get to any kind of implied commercial agency here. Well, let's think about small business, a restaurant owner, something like that. They tell their cashier, well, let me know if you hear the customers complaining about the food or talking about it. You can reasonably expect that if the cashier overhears something, they're going to tell you, but you can't expect the cashier to hack an iPhone, to interrogate someone, to beat someone until they start giving answers.
What about the hint, nod, wink, yeah, we're not really asking you to do anything, but if you get us some information on somebody, you're going to get a less sentence. I mean, you're not saying go after this guy or go interview this guy, but you're putting the bait out there. I mean, and I think that's what disturbed the court, and that's somewhat disturbing to me a little, because I don't think you could have a bright line or strict rule. You have to ask them or instruct them. I mean, there's all different ways to instruct people to do it.
I agree that there are circumstances with the wink and the nod that we might, in some extreme example, get to implied agency. The problem, though, is that this is the defendant's burden, and we don't have any of those facts in this record. In order to get, I think, where your question suggests, where we assume some wrongdoing by the police, we'd have to approach these cases with an assumption that all police officers are liars and all police...
It's not wrongdoing. It's that they're using a method that they think is proper to get information. That's not wrongdoing in the sense that it's wrong. The question is, when they use that method, what is the remedy? I don't want you to say that they're wrong, because I think it's probably good police work to do something like that. But the question is, did that good police work get you in trouble?
Well, Mr. Broller, let me ask you this question. Was there any evidence that this question or this statement, if you hear anything, let me know, whether that is a police interrogation technique or it's code for, hey, get some info and things will be better for you? Was there anything in the record that described that statement further?
I think it's actually rather the opposite. If we look at 979 in the record, that's of the trial transcript, Officer Smithy talks about, well, why didn't you give this informant a list of what you should do and what you shouldn't do? And his answer is that I don't want this informant to take any action, so all I tell him is let me know if you hear anything. The problem is the more the police officers tell the informant, do this, don't do that, we walk back into our agency problem, but from the other direction. Really, all the police officers can say is the same thing that they would say to the public. Tell us if you hear anything about this crime. And that's what we have happen here. And the context of that discussion is important. We don't know a ton about the context because our record here is so limited. But what we do know is that Carl Johnson, this informant, actually knew the defendant long before the police investigation started. He lived at these Broadway condominiums, or at least he was staying there. He was familiar with the defendant, Mr. Marshall. He knew Mau Mau, also known as Courtney White, and he knew Charles Thompson. Those are the three suspects the police are investigating. So it's no surprise that those are the three names that the police officers have a discussion with him about. Doesn't create any agency relationship. That's asking, well, we know you know these people. Do you know anything about this crime? That is the Polk County Crime Stoppers billboard. If you know anything, call us. There's no agency relationship in this record, because if there was, every time one of those billboard goes up, the 100,000 people that drive by would have an agency relationship with the Polk County Sheriff and with the state.
That's different. That's a contractual relationship for a reward. That's not a policeman to some suspect or someone in jail.
That's right, and that's why there's even less of an agency relationship here, because if you call the Polk County Crime Stoppers and you meet whatever their test is for useful information, you know that you're going to get the money that you were promised. The informant here didn't have any promise.
What if you went to your boss and said, I need the afternoon off on Friday? And your boss says, well, you really can't have the afternoon off. I really can't do that for you, but if you get this, and this done, maybe we can talk about it and give you some time off. I mean, is that an offer to get this, and that done so you get your Friday off? I mean,
I think if the statement that my boss made to me is that he could tell someone else who could tell someone else who could ask a judge if then maybe I could get the Friday off, that would be comparable. And the reason I say this is because the police officers don't have the ability to make any kind of bargain with these informants. The way it works is that the informant may or may not provide information. The police officer may or may not talk to the county attorney. The county attorney may or may not talk to the United States attorney. And the United States attorney may or may not file a motion in the district court. And then the federal district court judge may or may not grant any kind of reduction. That is about as attenuated as you can get. The way the federal cases talk about that is they call it a mere expectation or a hope of a reward. And the federal cases pretty much all say that that is not enough to establish agency. During my last couple minutes, I want to shift and talk about that third-pronged deliberate elicitation. This is what Judge McDonald is writing about at the Court of Appeals. And the reason his dissent is so powerful is because it points out that there is no evidence in this record whatsoever that there was a functional interrogation of the defendant.
And that, I'd like to just ask a specific question about what deliberate elicitation is. And I think you know the issue. The record does show that there was a conversation started at least, and please dispute me if I don't have the record right, because you've read 900 pages and I will read 900 pages. But the record seems to show that Johnson in particular engaged the defendant repeatedly, stimulated conversation. I think there's nothing in the record, Mr. Simmons, you can go up and challenge me if I'm wrong too, but there's nothing in the record that zeroes in on a specific interrogation, like, you know, what were you doing at the apartment on that date, and, you know, so forth. But he wasn't quite a listening post, in my view at least. A listening post strikes me as a cactus sitting there, you know, kind of listening to what's going on. He wasn't that. On the other hand, I think it may be fair that he wasn't doing a cross-examination like you'd expect at the police station of a suspect who had just been given Miranda. He's kind of somewhere in between. Am I right on the facts, A, and B, what is the legal implication?
Sure, I'm going to start big picture legal implication, because I think we just look at Rhode Island v. Ennis. This is interrogation the same way that we always use that word. We see in Wilson, the court, it's Justice Powell writing. He was also the special concurrence in Henry, which is important to remember because that's a narrowing of Henry. In his decision, he talks about how the purpose of these rules, the Messiah rule is implied to informants, is to avoid the equivalent of police interrogation. So to answer your big picture question, Justice Apple, I think we're talking about the same test we'd apply to police officers. Not every question is the functional equivalent of interrogation. It has to be very deliberate. It has to be eliciting specific information. Could there be some circumstance where it's implied? Could you have your Christian burial speech? Sure, but I don't think we've got anything close to that here. All we have in this record is one question. It is Mr. Johnson saying to the defendant that he asked what he was in for. This is not the functional equivalent of a police interrogation. We know that from the case law, we know from common sense, we know from pop culture. And there are two federal cases I want to just quickly talk about that really drive that point home. The first of those is the Rosa case out of the Second Circuit. There, informant asked the defendant, "What are you in MCC for?" MCC is the name of the prison. Second Circuit says that's not deliberate elicitation. That's not the functional equivalent of interrogation. Then we've got the Stewart case out of the Sixth Circuit, where the informant asked the defendant, "What are you locked up for?" Again, not deliberate elicitation, not the functional equivalent of an interrogation. Those cases are really our facts here. So what are you in for is not a detailed question asking for a lengthy explanation of criminal history, what you did, who was involved in the crime, etc. It's really a greeting. It's, "Hey, how are you?" but an inmate or detainee talk. We don't know a ton about how those conversations started. I think, Justice Apple, you suggested that perhaps Mr. Johnson approached the defendant first. I'm not sure the record shows that. What I think the record suggests, and this is 1468 in the trial transcript, is that it was the defendant who approached Mr. Johnson first. He started talking to me. Yes, that's in response to a question. I think the record, to the extent it says anything about how these interactions started, actually favors the state, because the state's not required to have their informant cover his ears or walk away when a defendant starts to give incriminating statements, to start explaining his crime. That's what the U.S. Supreme Court has said in Wilson, and they've said it in Maine v. Moulton. As Judge McDonald said at the Court of Appeals, the defendant's argument is really speculation, conjecture, and belief unsupported by the evidence. It's really a conspiracy theory. It's just not borne out by the record. I would ask this court to affirm.
What about, I guess, just one last question, what about in the special concurrence, of course, where you just have an uncanny coincidence of events that happen, and what inferences can be drawn from that?
I see my time's up if I might answer. I'm not sure we can draw any inferences because that issue wasn't raised by the defendant. I spent a lot of time looking at Judge Bauer's special concurrence to try and figure out exactly what Judge Bauer was saying. I wrote in our further review, I think the court split 1-to-1 because what Judge Bauer's writing about really seems to be a Fifth Amendment problem, and that issue is not raised in this case. It wasn't raised on appeal, and it wasn't raised below.
Thank you, Mr. Bowler. Mr. Simmons.
May it please the court. I am convinced that what the court should do to begin the analysis, I know you've probably begun the analysis already, but is take a very close look at the facts in the very beginning. And we often have to do that with cases. Let's go back to the very beginning. These are not, Martin and Johnson are not just a couple guys sitting in the Muscatine County Jail. As I said, and I borrow Judge By's words a lot, as I said, he would describe them as Detective Smithy's superstar informants.
I read that separate opinion, and I don't think the reference to superstar informants was to those people. But I do want to focus on the facts. What is Mr. Bullock correct that the only question that there's actually evidence in the record that Mr. Johnson asked Mr. Marshall was, "What are you in for?" Is that correct? And if not, can you point me to what else in the transcript shows that Mr. Johnson elicited information from Mr. Marshall?
That is probably the only specific statement that Mr. Johnson said he made. The problem here is that, and unfortunately Judge Mullins did it so that I think it affected what Judge McDonald did, the court has neglected to look back at the definition of deliberate elicitation that Justice Harris very clearly set out way back in 1982 in the Nelson case. And he took it right out of Henry, and of course he cited to Henry. And let me read it, because it's very clear. It's at page 120 of the Nelson decision. In Henry, 3 factors were listed as important in determining whether an informant deliberately elicited incriminating information. 1 was the witness acting under instructions as a paid informant for the prosecution. 2 was the informant ostensibly no more than a fellow inmate of the accused. And 3 was the accused in custody and under indictment at the time of the conversations. That is the definition of deliberate elicitation from Henry and from this court in Nelson. Unfortunately, Judge Mullins mentions Nelson's a few times, but he doesn't point to this definition of deliberate elicitation. And it's like the agency thing. And one of the federal cases I pointed out did a bright line on that as to what creates the agency. Once you identify for an informant a particular person you're interested in getting information on, and in this case, Smithy admits he specifically said on the Versipt murder, I need information on these 3 individuals. Once you do that, now you've got an agency situation. Now, Judge Mullins chose to quote from Cool Hand Luke. I liked, again, Judge By his quote from the searchers that I referenced in the brief. And that is, you go there and you say, hey, you hear anything, let me know. Well, that's not telling you to do something specific. And in fact, in Henry, the police officer told the informant specifically, do not question him. He went and did it anyway.
It's almost, you talk about agency and all that. you've done much more criminal defense work than I ever could have dreamed of doing in private practice. But I do know that when I had a situation where a federal convicted of a federal crime and facing long prison time, often they are very motivated to try to do substantial assistance before the time frame for doing that runs out. And you know, it's almost like I had clients that were more willing to argue that they had provided special assistance than prosecutors that were interested in anything than the clients had to offer of any kind. And I think, isn't that your experience some of the times as well?
Well, you know, whether the prosecutor is going to accept it or not is always a big question mark. But whether or not the informants are going to try is not a question mark. Presented an opportunity, they're going to try. And these two guys, Johnson and Martin, that's what I'm talking about. Smithy had been working with these guys. He knew they were good. They both testified against Martin's case that Smithy was working as a federal agent. Smithy was taking their proffered interviews. Smithy was involved in that case. He knew these guys knew what they were doing. He knew if he went and talked to Johnson, he didn't even have to talk to Freeman because he knew Johnson would tell him. They're a team. They're the superstar snitch team.
But that doesn't make them agents, does it?
Sure it does.
Just because they're motivated to get information. Just if you say, here's a crime I'm interested in, here's some suspects, that doesn't make whatever they do agents, especially when there's evidence that, in this case, Johnson actually questioned Marshall.
Well, and that takes us back to the John Wayne line. Do I have to draw you a picture? He doesn't have to draw a picture for Johnson when he talks to him. He knows Johnson knows what to do. Johnson knows that he knows what he's going to do. He's going to do whatever it takes to provide valuable testimony. And it's just the same as a paid informant. In Henry, the informant named Nichols was a paid informant, had been for the FBI a year before that situation. But it was a contingency fee. He only got paid if he provided information that the FBI could use. This is the same kind of thing. And Smithy is well aware of where Johnson and Freeman are in their frame of mind when you say, I need information on this guy. Do I have to draw you a picture? If the guy shows up, get some information out of him.
Let me just ask you, please. Agency alone, I take it, is not enough under the federal case law. Or is that not right? It seems, I mean, Mr. Bueller is saying it's agency and deliberate elicitation, and that seems to be deliberate elicitation is a requirement, right?
Right.
Okay. Let's assume you have agency, just for the argument here.
Okay.
But if the record showed that Johnson was the cactus at the jail and heard all kinds of incriminating statements, I take it that would not be a problem.
Well, that is correct. If
So, and then to go beyond that, what the record, as I understand it, shows, and I know you're going to help me, it shows at least Johnson asks the defendant, what are you in for? But is that enough to transform Johnson from the cactus, which would be fine, to the agent actually eliciting information which crosses a line?
Right. And the cactus, I think if you look at those cases, those are situations where the cactus hears the guy say one thing. You know, I heard him say to another inmate, yeah, I did that robbery. That's it. Johnson testifies he's taking note. He's going over there every day when they have 1 hour free time in segregation. He's going over there. He's talking to him every day during that time. He's taking notes so he can remember everything that comes up in the conversations, so he can tell that to Smithy and try to get some time off his sentence. It's not a situation of, if you hear something, let me know.
You're
and he
inferring.
just listens.
You're making an inference, I think, and the state would probably say this is speculation. But the inference you're making as well, and the inference, I guess, that the Court of Appeals was making too, was, okay, they're deliberate proximity, if you will. They're sharing the same jail, Muscatine. How, my heavens, they all end up here. We know, I take it, that the question, what are you in for, was posed. And then we also know that there was note-taking. And from that, we can infer that there was, I take it, a dialogue of some kind that amounted to deliberate elicitation. Is that your position?
I'm not quite clear on what that question is, Your Honor.
Maybe that wasn't clear. Let me try it again. We do know that the question was asked, at least, what are you in for? And we do know that he took some fairly elaborate notes of what the conversation was. From that, do we conclude that there was an interactive process of some kind that amounted to deliberate elicitation? I mean, is that your position?
That is my position, and I think that's exactly what Henry and this court's Nelson case say, is that look at the nature of the information that this informant says he got. You know, you've got a bunch of circumstances here. The note-taking is a great thing, but see how that evolves. Then Martin and Freeman, they're not only taking notes, which they both say they took extensive notes, they're also telling him what he should say, what should be his story. They're starting to counsel him. There's an evolution there.
Why aren't Martin and Freeman entrepreneurs, if you will, rather than agents? I mean, their experience with the criminal justice system, and they know that if they can gather some valuable information, but the information that they gathered was prior to October when they met with Smithy and the other officer, I think. Do I have that right?
Right, and you know, I did point out in the brief at pages 41, my main brief, not the resistance to the further review, but my main brief at pages 41 to 53. I just pointed out all the testimony where they're all saying, "Well, I don't know this guy. I didn't talk to this guy about." Mr. Marshall, I don't know how Marshall got to, and they're all tangled up. You know, Martin saying, "Oh, I talked to Johnson back in August." Johnson saying, "Oh, I never talked to Martin until October," and I've got it all out in details. I won't try to argue it here because it just be too tangled up. But that's what it is. It's a tangled up web that he's thrown into.
You have a tangled up web with these. All three of them are confidential informants. They're trying to turn into that. So they've got their own little agency or their own little business going on here. But is there any evidence in the record that while these conversations are going on between Johnson and our defendant here, Marshall, is there any back and forth with the police that are telling him or feeding him information? In other words, well, this is what I talked to him about yesterday. You know, is there anything else that you want me to ask him, or any other dialogue? Is there any interaction between the police and this individual at any time?
No, there's no evidence.
The full disclosure of all this information?
There's no evidence that Johnson talked to Smithy again between July 12 and then September 19th when he told Smithy everything he had. There's no evidence that there was any back and forth or anything like that. And there was good cross-examination brought up. That you have to remember what was happening is in September, Thompson was going to trial on this very same murder, and it was all in the newspapers in Iowa City and elsewhere. And there was good cross-examination on that these facts were out there, that inmates could have learned facts from the newspaper, and who knows how else they could have learned it from their own people who are gathering these facts. The point is, these courts, Henry and the Nelson court, say, look, it's rare that a defendant is going to be able to develop this information as to how all these things occurred for these deliberate elicitations. These are the factors to look at. This is all we care about. The rest of it is, like John Wayne, do I have to draw you a picture? You know, we know what's going on.
Part of the picture is that these two fellows, Johnson and Marshall, ended up in the same cell together. And as I understand the record, and tell me if I'm wrong about this, there's no evidence that the state made any deliberate attempt to put them in the same cell in order to get information. And there's no evidence that Smithy and the other officer knew that they were going to end up in the same cell
Right,
together.
and that's
Is
just
that
what the
fair?
courts are saying. How is a defendant ever going to develop that information? Just take the police officer's word, no, I didn't do that? You know, it would take a grand jury investigation to trace all this stuff back as to who recommended somebody should be moved and why and when and all of that. What they're saying is, look, we've got an agent here. He's created as an agent when we tell him who we want and what it's about. We've got a deliberate elicitation here because look at the body of work. They're having, admitted by Johnson, multiple conversations, admitted by Martin and Freeman, multiple conversations with this kid. He was only 20 years old when he went in there, by the way, and that's supported in the record. These guys are a lot older and more experienced. What I would like to say is, you know, this is not great police work. I have to disagree with Justice Wiggins on this. This is primitive police work. When Messiah was coming to prosecution in the early 1960s, it was old school then. They were desperate. When they get desperate, then we'll go to old school techniques. You know, 50 years later here, we're trying to still say, look, you cannot send somebody to do your bidding with a defendant who's represented by an attorney on this charge. You know, it has to be made clear for the police officers. In this day and age, with this court and other courts, state legislatures, even the FBI and other law enforcement organizations are pushing, always record every interview and every interrogation with suspects and record the whole thing. It's not just because judges and juries, you know, are interested in whether it was coerced or there were promises of leniency and everything. It's because we also want to know everything that was said and how it was said and why it was said, context to statements. This type of primitive police work is the total opposite of that type of trend. It's giving the police still an option to use surreptitious techniques on a person who is represented by counsel. And I appreciate the extra time. And I think that not just focusing on who these informants were and what was going on at the time that Smithy went to talk to Johnson, I think also focusing on this is a right that this court very jealously has protected for, you know, ages, the right to counsel. Once you have a lawyer, the police should not be interfering with that relationship. That lawyer actually is sitting in that jailhouse with that client. That's the way they have to look at this. And to get back to Mr. Buller's billboard, I can't resist this. Quit Smithy put up a notice in the jail. I'm Michael Smithy with the Iowa City Police Department. If anyone in this jail has information on Mr. Thompson, Mr. White, or Mr. Marshall, please give me a call. Here's my phone number. This is a totally different situation where a man is incarcerated, separated from his lawyer, and in this case, the record shows his lawyer was actually in Des Moines and he was in Muscatine. That was part of the weakness he had that allowed these guys to descend upon him, is he wasn't visiting with his lawyer. He didn't have any confidence in his lawyer because he wasn't seeing his lawyer. So I think it's extremely important that this right continue to be jealously guarded and be protected from police procedures that clearly violate attorney-client relationships. If there are any other questions, I'd be glad to address those. Otherwise, I told you last time I was here on this situation, I just hate not having rebuttal, but I certainly appreciate the time you've given me, and I especially appreciate the extra time. Thank you.
Thank you, Mr. Simmons. Rebuttal?
May it please the court. My friend representing the defendant wants to talk a lot about Henry, but I want to talk to you about Wilson, because Wilson is the law and Henry is not. We could quibble about, did Wilson overrule Henry? Did it narrow it? Are they somewhat inconsistent? Doesn't matter. Wilson came later. Wilson is clear. The commentators, to the extent they engage on this topic, all say that Wilson narrowed the right President Henry. And under Wilson,
Your view then is our Nelson decision is also outdated.
with the caveat, to the extent it relies on Henry, I do agree with that. I think even under Nelson, we really have the same kind of deliberate elicitation test that we're looking at under Wilson. Is it the same kind of functional equivalent to police interrogation? It's important to remember that in Wilson, it wasn't a cactus, it wasn't a completely silent person standing in that cell. The informant in Wilson talked to the defendant. He said things like, well, your story doesn't sound too good. Well, that's the equivalent of what we've got here. So what are you in for is not a detailed police interrogation question. It's not a heavy-handed police officer saying, where were you, who did you do it with, did you participate in the murder? It's the equivalent to a greeting. It's the same reason that when I stood up here and said, may it please the court, nobody thought I was asking for a detailed explanation of whether the court is in fact pleased to hear me. We make these kinds of conversational tics every day. I pass someone in the hallway, I say, hey, how are you today? I don't expect a 10-minute answer. I'm not interrogating them. I'm making an empty greeting, a social nicety. That's what we have here. The only question that appears anywhere in the record is, hey, so what are you in here for? They had a past relationship. They were friendly acquaintances, if not friends. It's not surprising that that's how they would interact. There's no police scheme that set this in motion, and there's no evidence that the equivalent to that interaction, so what are you in for, is a police interrogation. I want to step back and talk a little bit about the story that I think the defense has woven today, and it's a good story, it's interesting. The problem is that that's not what's in the record here. I think it is generous to say that that is drawing inferences. I think a more correct description is that is rank speculation. That is an assumption that everyone in the system is stacked against this person, that they are making bad decisions, that they are out to get him, and they're going to do whatever it takes. There is no evidence of that whatsoever anywhere in this record. The police here were trying to do their very best. And the burden of proof matters. The defendant had to prove by a preponderance of the evidence all three of those requirements under the Sixth Amendment. The defendant has not proven that there was probably an agency relationship. All we have here is an informant who hoped that he might get some kind of reward if person A talked to person B, who talked to C, who's talked to D, and eventually maybe if he's lucky a federal judge does something. That an agency relationship does not make. The defendant has also failed to prove that there was probably the equivalent of a police interrogation. So what are you in for? Is not a police interrogation. According to the record, that is the only question that Carl Johnson asked. The record matters and the burden matters. And on
What do you make of the notes? The notes have some considerable detail. I mean, it's not a transcript, clearly. But is there any, can one fairly conclude from the notes that there had to be some kind of, give and take conversation going on that might cause you more problem than the good morning, how are you?
There's no reason to think that Carl Johnson asked a single question beyond what's disclosed in the record. We know that unfortunately, or fortunately, depending on your perspective, defendants are going to run their mouth. They're going to talk to people. You and I might realize that's not a great idea, but we see this all the time. Defendants make spontaneous statements. They make voluntary admissions that are essentially unprompted. The defendant had the burden to show that that's not what happened here.
Do you really think it's, I mean, I've looked at the letter, you have too, of course. Do you really think it's likely that that was a monologue?
I think that it is.
I'm not sure I know what the questions were. I don't know, but I really doubt that there was just a long 10-minute Shakespearean presentation.
Was this Hamlet? Probably not. I don't think so. But what we do know from the record is Johnson approaches the defendant, not the other way around. The only question that's disclosed that Johnson asks is, so what are you in for? There is no reason to think that after he made that very brief, empty greeting, that the defendant didn't just spill the beans. He very well may have just said, well, I'm in for killing the guy that was at the apartment building. That is not an uncommon set of circumstances.
It could have been a discussion, but not, or a conversation, a dialogue, but not an interrogation.
I think that's exactly right. And to the extent there was a discussion, it's one initiated by the defendant. The police are not required to walk away from a defendant who wants to make incriminating statements. The record does not show agency or deliberate elicitation. I would ask this court to affirm the conviction.
Mr. Bowler, thank you. And all the arguments this afternoon were very informative. We appreciate it. The case is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.